so one thing we see a lot of is medical records. And I heard that you guys have been working on charting, and a lot of you guys have charted and done your run reports before, but I think this would be a good refresher on, what to do, what not to do, and some real world things that happen in litigation down the line. And hopefully none of you guys will have to experience that, but if you do, I'd like you to be prepared. So here's an overview of what we're going to go over today. First is medical negligence or malpractice claims. That's just the general law in Ohio, how those cases are decided. Second, there is a different legal standard for most paramedics. Usually you work for either a government or municipal organization, or you work for a company that contracts with the municipal organization. So you guys actually have a better, higher standard to be held accountable. Third, we'll talk about medical records and charting, obviously. Fourth, minimizing risk. 5, what to do if you are ever sued. You do not want to mess that up. And 6, significant paramedic cases in Ohio. Real world examples of when things went wrong and what happened. So if you ever have any questions, comments, I'd like it to be an interactive presentation, but I know that that's sort of difficult with the PowerPoint. So cut in. Okay, what is medical negligence? So a claim for medical negligence has 4 main elements: duty, breach of the duty, proximate cause, and damages. So mainly duty in a medical malpractice case has to do with the standard of care, what a reasonable paramedic in this area would do in the same situation. That's the standard. Not what the best paramedic in the world would do, not what a paramedic would do in California. It's got to be from your area geographically, and it's got to be within that standard of care, which is pretty wide. So there's that. Breach of duty means that you were supposed to do something and you didn't do it, or you were supposed to not do something and you did it. The breach has got to cause the injury, so that's the element of proximate cause. So you've got to have a negligent act, and in its natural and continuous sequence, it's got to directly produce the injury. So we have a lot of arguments. If someone, every person you see has a pre-existing condition, right? That's why they're calling you. We've got a problem. This is what it is. So that proximate cause factor really does come into account in a lot of cases. And then fourth is damages. These are usually a no-brainer. If you can get the first 3, you're going to get the 4th one, because usually somebody is either injured very seriously or has died. So like I said, you need a link between the breach and the damage. Just because you've done something wrong doesn't mean that you can be held responsible. You've got to have caused it. And medical malpractice cases, even ones involving paramedics, deal with a lot of expert witnesses. And so each side will hire an expert, usually a paramedic and probably a doctor in whatever specialty is involved, to give an opinion about the treatment that was provided, what should or shouldn't have been done. And then the defense also hires experts, so by the time you get to trial, it's sort of like a he said competition. The jury's going to hear both sides, and they're going to kind of sort out what they think is correct. And a bad result is not enough. We see, you deal with sick people, terrible things happen every day. Just because someone had a bad result doesn't mean that there was medical malpractice. So, yeah. So this is really a boring slide that probably makes your eyes glaze over, but I'll give you the high points. This is the standard for paramedics working for a municipality. So basically what it says is, if you're working for a municipality or a company that contracts with a municipality, you are not liable for damages in a civil action unless your actions constitute willful or wanton misconduct. That is one of the highest legal bars that there can be. So you guys are pretty well insulated by the law as it is right now, unless you do something that is willful or wanton. And those words are defined as such. Willful and wanton misconduct needs more than negligence. You've got to go above doing something unreasonable. You've got to act deliberately or with reckless disregard of a known risk. It means you fail to exercise any care to the patients that you're seeing. And it means that you've acted with intent, purpose, or design to injure, which is probably the exact opposite of what you guys are doing on a day-to-day basis, trying to help injured people, not actually injure people. So the standard's pretty high, and exceeding that is difficult, but I will show you some cases later where courts have ruled that a paramedic's conduct may be willful and wanton, and that issue is something for a jury to decide. Medical records. What is it? It's data in any form that pertains to a patient's medical history, diagnosis, prognosis, or medical condition that is generated and maintained by a healthcare provider in the process of the patient's healthcare treatment. So there's been a recent Ohio Supreme Court case that says that includes cardiac monitoring strips. These strips in that case are deleted after 24 hours. Plaintiff alleged that those strips should have been kept. The Ohio Supreme Court agreed. Video, we're seeing this more and more in our cases that either patients or patients' families are taking videos of incidents, which sometimes leads to less clarity as to what actually occurred. Because when a lawsuit is filed, it's usually a year or so after the event. Memories change, not just from the professionals involved, but from the families. And so videos sometimes are very difficult, and if for some reason you have a video, that's something that needs to be kept in the medical record. And then finally, text messages. I don't know how many of paramedics are texting potential patients, but that does sometimes happen with doctors and nurses, and those should be in the medical record and can be used in court. So, so that's sort of the cutting edge on what goes in your medical record. It's not just your EMR or your old school paper files anymore.
Like our I am responding messages and everything, like when we're texted, like address, or run, do those constitute as that, or is that fall under?
Are you getting information about the patient's medical condition?
I didn't get a chief complaint, but that's a...
Yeah, I'd say as long as you're not getting a lot of patient information, probably not. I'm sure there is some attorney out there that's going to try to get those from a company if they think they might have pertinent information. But usually whatever the chief complaint is going to end up in your run report, so ideally that information will be captured subsequently. So, purposes of medical documentation. These are all about why it's good to have accountability, get paid, comply with the law and your practice standards, provide information for research, all those things. So, this is why it's important to document things. You guys see many patients on any given day. You can't remember what happens, all the details with every single patient. At least for me, I don't do medical records, but what I do have to do is bill my time in tenths of an hour. So every 6 minutes of my day is captured. I can't tell you what I did 2 Tuesdays ago. I have no idea. I could maybe go back in my email and see, okay, well, I sent some emails. Maybe I was working on this. Maybe I was working on that. But just like you guys, contemporaneous record keeping is always the best record keeping. So getting that down quickly is important. Patient will remember more things than you. Very typical. I mean, this is a traumatic event for them. It's going to stick out for them. For you guys, it could be an every Wednesday type of call. So they're going to remember more than you on some things. And I can't tell you how many times that a patient's recollection has been different than what the professional's recollection is. That happens very, very often. So good charting is your best ally. Jurors are inherently suspicious of testimony. When you get up there and if you're testifying to a jury, the other attorney's going to say, well, if you didn't write it down, then you didn't do it. You having your own independent recollection of, oh, I performed this test, or I checked for this, or the patient told me that, and it's not in your records, that's going to set off a jury's BS detector very quickly. So it's really important, I know it's a common saying, but not charted, not done. Nobody is going to believe that you did it if you didn't put Your credibility is very important, so we're going to want your testimony to match your medical records. This is what I did, I came in, this happened, oh look, guess what, I also wrote it down the same day. That's going to make you look very believable to a jury. And good records to get paid. The basic information that should be in a medical record. Objective and subjective observations, especially changes in health status. Your objective observations are very, very important because the patient's only going to have their subjective observations if this were to be a litigation down the road. Document actions you take in observations of the patient's response to your actions. If there are any changes in that response, put that client outcome down, especially if it deviates from what you would expect. And then finally, if there's any verbal or nonverbal response to the care you provided, get that in there. The patient states, the patient's family states. And that indicates that not only did you provide care, but you evaluated the results of your care. So that's an important analysis.
Coming through the program all the years, they always told us, like, if we went on to a intoxicated patient, what's your opinion? Do we say we smelled alcohol? Do we put that in there? Do we not put that in there?
What I would put in there are any observations that you can make that would indicate the person is intoxicated. So rather than saying, person was intoxicated, you would say, I've observed slurred speech, I've seen a lack of balance, I smelled an odor of alcohol, all things that are objective rather than just your opinion.
Okay.
I think that's important to back you up. And I think I go into that right here a little bit.
I just led you right into
So
it
you're
then, right?
just doing great. Yeah, you don't want to use words that suggest a negative attitude. So you don't want to say someone's stubborn or nasty or drunk or weird. There's other words you could use. If they're non-compliant, put in there that they're non-compliant. If you feel as though they're under the influence, put in there the reasons why you think that. But make sure you avoid negative attitudes or opinions about patients, because that's going to be very suspect to a jury if they were to see the record. Oh, you put this in there just because you didn't like this person, or you have a prejudice against people that are like this or that. You want to avoid that. Don't use shorthand or abbreviations that aren't widely accepted. That's can be very difficult. I don't like arguing over what these letters mean with plaintiff's counsel. Try to avoid vague descriptions like a large amount or fluid on bed. Try to quantify things as objectively as you can. Don't give excuses such as medicine not given because not available, or you didn't have the proper equipment. Don't chart your opinions, as I stated before. Try to get as many facts in there as you can. Don't be wishy-washy. Appears to be, apparently, I suspect, all those things. Don't chart ahead of time. I don't know how you guys could possibly do that, but I know that happens very commonly with nurses that are rounding on the same patients day after day. So make sure you're charting after it's happened, because you might think, oh, I'm going to do X, Y, and Z, but then something happens and you didn't do X, Y, and Z, and now it's in your record and I'm stuck dealing with it. Don't chart care given by others. Chart your own care.
Sarah, what if you're responding, you have first responders on the scene before you that have done something, though? That has to be in there for continuation of proper care, though.
Correct.
Okay.
Yeah, that's a good clarification. If you're not the first one there, then yeah, you want to give the full status of what's happened when you get there. And please, please, please don't use words associated with errors. Don't say by mistake, accidentally, unintentionally, miscalculated, confusing. Those are just like a big, giant money sign to plaintiff's counsel. They would love to get a medical record that says something happened by mistake or unintentionally. If something happened by mistake, you can still put in there what's happened without adding those very difficult words for us to argue around. So I know now we do a lot of, you guys are all doing EMR, right? But if for some reason you have to write something down, please, please make sure we can read it. Like this medical record here on the right, I think that big swoopy thing on the bottom is somebody's signature. As to who signed it, I don't think anyone could tell you. In addition, you know, the words themselves are very hard to make out, which makes it very difficult because there's sometimes a lot of argument about what's actually in there if we can't read it.
Sorry, just the handwriting thing made me think of this. Going back to what needs to be part of the patient's records, if we like write down vital signs on a vital pad or make notes on a piece of paper, should those go with their records?
I would put that information right in the EMR.
Okay.
That's what I would do now. Instead of worrying about, oh, did I turn this in to the company I'm working for, I'd get that right into your chart.
But you don't have to attach like
Right.
your glove or, you know, something like that you're writing on. You just put the information into the EMR, but you don't have to worry about attaching the
Right, and then you never have to worry about legibility, and it will help because when the patient, you know, goes forward with their treatment, it'll be good to have that information in the record for the physicians down the road. But that's a good question. So I'm sure you guys have gone over lots of types of charting. These are some common ones. There's no really wrong, well, there's lots of wrong ways to do it, but there's no form that you need to follow. Obviously you want to get in who, what, when, where, why, how, all of those things. But any of these approaches could be correct. What do you guys usually teach?
I do the narrative form, it's a story, they start from the time of dispatch with what, to the time they deliver the patient to the nurse at the hospital.
That's a very,
In chronological order.
yeah, that's a very organized way to do it for what you guys are seeing on a daily basis.
Now, along with doing that, I know I've been taught in the past too, if it's in the drop-down boxes where you can check mark things, that should or should not be in the narrative. Because I always heard if you shouldn't duplicate it in case you write it wrong in the narrative, and now
Right.
you have conflicting items.
Yeah,
Is
we
that
see
correct?
that very common now with the EMR, that there is conflicting items. If you've got it right in the drop-down menu, I don't think you need
Should
to
repeat it.
include it in the narrative. But strangely, we do have a case right now. We're not representing this doctor, but his defense is, oh, the EMR didn't have the correct drop-down menu, so I couldn't put in the information that needed to be in there. I don't know that that flies.
I know old school guys like Mike and I, we started with narratives because there was barely anything else. So it's hard for me to leave information out of my narrative. I'm still practicing and doing that.
Yeah.
But if it's up there, I try not to repeat it. So if I transpose a decimal point for drugs or something.
Right.
So,
Yeah, I think that's a good way to do it. I mean, the reason they put those drop downs in is just to get consistency so that everyone is reporting what they need. But yeah, if you've got it up there, I don't think you need it twice.
What I've told this group is in the boxes, you know, it'll say the time, it'll say IV of normal saline, and you know, whatever drip rate, and then the complication of the reason why you did it. So on the narrative, I just have them say IV established because everything else is up here.
Right.
But it keeps it in that order is why I do that.
Yeah, I think that's a good way to do it. So I've got a few examples of actual charting. They're not all from paramedics. So this first one's from an LPN. You'll see the charting on the left is short and kind of vague. We don't like words that suggest safety issues like strangulate. On the right is much more thorough. It's got a follow-up, so the evaluation of like fixing the problem is in there. That's very helpful. That there are no more complaints and that they're going to continue to monitor. Another one on the left, very brief. Skin tear, clean and applied this. One on the right, we've got what the measurements actually are or appear to be. More of what was actually done. If there are any further complaints, if there is any sign of infection, you know, and if they decline transfer or not. So what you really need is that assessment. That's key. I think I've got one more. Yeah, this one's from an RN. The first one, very short, seems sort of sweet, but doesn't really give a lot of details. So now we've got a pain scale, we've got something about there's no numbness or tingling, the drugs that were ordered and the dosage, that's very important. And then the length of time the heat therapy was applied, and the deadline for reassessment. Document anything significant. All discussions, any warnings that you've given, what your plan of treatment is and what you've done, and if there are any negative results that are making you go one way with your plan versus another. Yeah, and text messages with your patients. It's happening more. If you keep those texts, it is a medical record. Don't really want to do that because obviously there's a HIPAA issue, and if it is significant, then other treaters can't see it. It's not contained in the patient's file. It's just information that's out there that is not really useful to anyone except to get you in trouble.
What about taking pictures of the medication list? And then either attaching the picture to the report or entering individually into the report?
I think that's fine.
And then delete the picture out.
Delete the picture, make sure it's in the report, either attachment or typing it out, depending on how long it takes. But really the end thing that you need to think about is, is this information in the EMR? If it's not in there, someone else isn't going to be able to see it. And if someone remembers from the family or the patient themselves that, oh yeah, I told the paramedics I was on X, Y, and Z, and now no one at the hospital knows, it's going to be a problem.
And it's okay to delete that picture afterwards. So.
Right.
Okay.
Now, what if you use, like we use iPads at a couple of my stations, whether it's an injury accident or taking pictures of the medication list, that is a city or township item.
Right.
Do we have to delete those? What do we have? Like medication lists, I understand delete them. Accident scenes.
That's very interesting. So it's owned by the county or the company that you're
Correct,
working for. Do they have a policy put in place
We are
as
allowed
to?
to use those to take pictures, because if we go into the ER or something for an accident, we can show the doctor.
Right. Is there any policy about how long they're gonna keep those? Yeah. See, that's probably part of like the storage, right? I mean, however much room you get on these
Yeah.
iPads, you can't save every photo that you've taken. So they've probably got something in place as to, these are gonna stay on there until we run out of storage or in a week or however many 24 hours. So I don't think that's something you have to worry about as long as it's coming from the municipality and not your own personal iPad.
Could you attach them to the report?
You could.
And
That
then
would definitely solve part of the problem. It would be probably useful to people later on, those accident scene photos.
Correct. That's kind of what I was getting at, more like the training aspect, especially for car accidents and things like that. If we're allowed, if it's a company thing, can we keep them, what can we do with them?
Yeah, I would say, leave them on that iPad. Don't do anything with your personal devices. And then if you want to attach to the report, that would be a good way of handling that. Because then you don't have to worry about HIPAA. Because HIPAA is a pain.
Yes.
Minimizing the risk of claims. So you can't always avoid them. Sometimes a bad result happens and people are going to sue, and there's very little that can be done about that. You do want to be careful about your medical advice to help minimize your risk. Alright, stay current on what's going on. You guys are all here, so you probably can check that off. Document significant events and discussions. Document close in time to treatment, like we said. And please avoid documenting criticisms of care provided by others. That would be very helpful. Like I said, if you keep your opinions out of there and you stick to what you observed and what the facts were, that would be a good way to look at it.
I've had it happen to me actually as recently as yesterday. I work called to a nursing facility that what we were dispatched for and what was actually going on with the patient are two totally different things. So I put in there what the staff had told me, what we were dispatched for and what I had observed.
Yeah.
So
I think that's the perfect way to do it. That's all based on information that was provided to you and your own observations. You're not saying in there, I would hope, you know, staff misinformed or lied to dispatcher, was dispatched for this and then found out it was that. You know, you want to keep all those judgment words kind of out of it, but putting this is what happened, I think you're completely fine. Okay, dealing with patients after a bad result. I don't know how often you would see them again, but on the chance that you do, like I said, a bad result is not negligence, and there's really nothing wrong with compassion. You can express sympathy or compassion with a patient. What I would like you not to do is say that you are at fault or that you should have done something else, because if you admit liability, that can come into evidence. So saying that you're sorry or you're, you know, really, you know, unfortunate that that happened and you wish them well, that's fine. Saying that you caused something to happen or you could have done this or you could have done that, that's not helpful for anything down the line. Never alter your records. So you don't want to change your EMR records, because that will make you liable for punitive damages, and punitive damages are something that you would be individually responsible for. There's no insurance policy that will insure you for punitive damages. You've got to do something very bad to get them, like fraudulently altering a record after the fact. And with EMR now, they're going to find out. So I wouldn't advise doing that. If you do have something you need to change, you can always make a supplemental note or addendum. Just make sure you date it. That's a lot better than going in and adding after the fact.
If you go in and, I used to do the QA for a department, and if they make mistakes on times or just little things like that, is that okay to go in and correct, or does it have to be done by an addendum also?
When are you changing it?
It would be after the fact.
After the fact?
Yeah.
I would say, if it's after the fact, I would do it by addendum. You know, like, time was originally listed at this, but based on however you got the real time, you know, from whatever record, now it's really this. I would
Okay.
just do that to make sure you're safe.
Gotcha.
Again, never alter records. It is basically impossible to defend a case if you alter the records, because no jury is going to believe anything that you say. The cover-up is worse than the crime. I know that's a, you know, cliche, but it's very true. They will hate you, and they will put big numbers down on the sheet of paper. So, don't change your records, please, please, please. Okay, how long do you have before somebody files suit? Statute of limitations for malpractice is 1 year plus 180 days. So that starts when there's an event that the patient should have discovered is malpractice. So for instance, if a patient goes to a doctor and they have complaints and the doctor runs a test and says, you know, you're fine, there's no issues, that mole is benign. Then they find out 4 years later that now it's cancerous and they've had cancer the entire time. The statute of limitations doesn't start running until they find out about the malpractice. So if they have no way to know, it doesn't start. But at the bottom here, there's the statute of repose. There's limited exceptions, but generally it's got to be within 4 years of the medical care.
Does that change with a pediatric patient?
Good question. It usually would be suspended for a pediatric patient until they reach the age of majority. And then then the timeline would kick in. So they would go, you know, you'd have to file suit by the time you're 19 and 180 days old.
So like that example you said, with like the doctor finding that cancerous growth 4 years later, would that like fall in the statute of repose?
If it was 4 years later, then the statute of repose would allow it. If it was 5 years later, they'd have to try to get one of the exceptions. So generally that would be barred. The reason for the statute of repose is they want these claims brought within 4 years because, you know, witnesses move, people leave, you know, they want to try to get them as fresh as possible because that's when you're likely to get the fairest result. But in situations like that where the patient has no idea, they can try to request one of the exceptions. And then a wrongful death claim is 2 years from death. So and that would be brought by the decedent's estate.
So how would they prove that they recognized a problem?
So they would have, one of the interesting things about those cases is, let's say let's go back to my cancer example. They go in for a test, doctor says it's not cancer, 4 years later they find out, oh, that test was read incorrectly and it really was cancer this entire time. One of the things they look at is, are there any symptoms that the patient had in that time period that should have indicated to them that they may have had cancer or that they needed to go to the doctor for a follow-up? And so they'll analyze what actual medical symptoms and care was provided between those two dates, which is very interesting. But those are, kind of rare.
So if they came in 2 years after the cancer thing was cleared and looked like they didn't have it, and after that doctor's appointment, they came in because of a complication with that, then would the marker start then?
Yes,
And that means that if 2 more years passed, they couldn't do it?
you got it.
Okay.
Once they're on notice of it, they've got a year and 180 days.
Okay.
So that's one of the arguments that we had, is when they're really on notice.
But that
What
has to be
should
on
have put them
medical
on
record.
notice? What'd you say?
Oh, that has to be on a medical record though, right?
Yes,
Okay.
all that stuff will be contained in the EMR, unless someone's doing a terrible job charting, and then I've got really big problems. Yeah. So these are legal documents that you will hopefully never receive, but you might want to be on the lookout for. The first one is a 180-day letter. So under Ohio law, a attorney that represents the patient can send you a letter and putting you on notice that there is a potential claim against you. It's called a 180-day letter because it buys them 180 days to file suit. So that's why when I said malpractice is 1 year plus 180 days, that's why that weird number's in there. So you might get something like that. The second thing you might receive is a complaint. It usually comes with a summons, generally served by certified mail. I don't know if you've ever received that, but the post office carrier will come and have you sign a green card saying you've got it and that's what you need for service. And that complaint will contain a lawsuit with the legal allegations against you. So if you ever do get one of those things, you need to contact legal and forward the suit papers. So I would suggest that probably through whatever company or municipality you're working for, you need to contact their legal department or someone in the administration and move those papers along, because the 180-day letters, those have a little more time, but a complaint generally needs to be answered within 28 days. So it's not something you want to sit on. If you don't answer within 28 days, they can get an automatic judgment against you, which is not good. So make sure you talk to someone about that. Obviously, if you have an attorney, speak to your attorney. You're probably all covered by some form of insurance from wherever you work. Those insurance companies will provide you with an attorney. Make sure you cooperate with them. They'll want to meet with you. What I always tell my clients is, you don't need to hide anything from me. You have to please be truthful with me. If you hide things from me, it's impossible for me to change course in the case and get them figured out. So you should never really feel hesitant to be truthful with your attorney, because they can do a lot more with the full facts. Even if you feel like maybe I did make a mistake or maybe something didn't go as planned, let them know and they can deal with it. If you're sued, please don't speak to the patient. That is bad. Speak to the patient's attorney. That is worse. Speak to your colleagues, because they could be subpoenaed and testify. Please don't do independent research. Probably like the patients you see, Googling things is not the same thing as getting a lawyer to give you a professional opinion. I know I've looked on WebMD and I have a lot of different medical ailments, but it turns out I don't have any of them. So same thing with your lawyer. Just because something happened in one case, or when you Google things, you'll find stuff from all 50 states, and that's not what happens in Ohio. So there's very specific things in each state. So don't Google, and don't do them, because those things can all be discovered in the suit, which means the other side will find out about them, and if they're bad, they'll tell the jury about them. You are your best defense. I will say jurors have a lot of respect for EMTs and medical professionals. They want to hear from you guys. They know you're doing a big service for society and the community, and they are set up to generally like you. So they're gonna want you to be up there talking to them about what happened, why you did something, that you followed it, and you know that all those steps are in your medical record. If records show these things and you can explain them, you'll minimize your risk of claims. Like I said, if the medical record matches your testimony, you look very believable. So, what I put here at the end was some significant paramedic cases in Ohio, which I looked up and I was surprised as many as there were, so I'm only giving you 3. So this first one has a lot to do with a chronology that was put into a report by a paramedic. So here's the factual scenario. Mr. Mitchell was gasping for breath and having trouble breathing. His wife calls 911. EMS arrives and they place an ambu bag over his mouth and they start chest compressions. Defibrillator pads were placed over his chest and the EMS personnel tried to defibrillate. So the wife is there during this time and she's seeing that the defibrillation is not working. There's no shocks. She heard the EMS personnel say they couldn't get a connection in order to shock Mr. Mitchell. So the key evidence in the EMS run report was critical to this case. So here is one. I mean, it's pretty thorough, I will say, except for there's one thing that I don't like because it's crossed out. So what you'll see is the shock attempts. So the Zoll, is that how you say it? Zoll, it's not working. And a second crew arrives, 2 minutes later, bringing the life pack that is working, but the paramedics continue to use the Zoll. 3 times. 4 times. And then they switch to the life pack. So Mr. Mitchell passed away, but this chronology was crucial to the plaintiff's case. So basically their claim was the EMS personnel should have used the life pack once it got there at 49:45, and continuing to use the Zoll, which was not working, was, according to them, willful and wanton. And I will say the court ultimately held that EMS personnel's actions were not willful and wanton. So, like I said, it's a very high bar, but other than the entry at 53 that's sort of crossed out and it's sort of difficult to tell what happened there, I think this is a very detailed report that ultimately supported their case, because you want to have everything that was in there. Even though something bad happened, the Zoll wasn't working, it's still not enough to hold the paramedics responsible for the accident. Okay, second one was from 2001. They only get to be cases if something terrible happens, so don't be put off by that. Plaintiff was dizzy and she had trouble grasping things with her left hand, and she had fallen twice. So EMS was called. They were there for 10 minutes, which was not a very long time, and they told her she probably had a sinus infection in the left. So one of the problems with the case was that the paramedic partially filled out the run report and only documented the falls, didn't document the trouble grasping things or the dizziness, just filled it out halfway, sent it in. And then of course the next day plaintiff suffered a stroke and wants to blame the paramedics. I think this is an excellent example why you need to fill out your run reports thoroughly. If they would have had a better argument and looked better to the jury. And I got one more, this one's very
I
sad.
assume they lost that one.
They did. First one you won, the next you lose.
I can't believe they would won the first one.
Well, willful and wanton is pretty high up there. I'm sure what they did is not something you would advise or train paramedics on, but That's just a very high standard to reach, which is, you know, good for you guys. So this is a pregnant woman. She's in her 3rd trimester. She's having serious bleeding. 911 is called. This is in Akron. Akron paramedics arrive and they take only her vital signs. They don't take the fetus's vital signs, and that's key to the case. Because her vital signs were not emergent, they called a 2nd unit to come get her. You guys might know better than me, but I don't know why American Medical Response would be better to transport her than Akron paramedics.
If they run.
They thought it was
off
BLS
on
call.
an engine or, you know, a medic unit.
Oh, okay.
Some people have just engine units that respond, and then they call like a private.
Got it. So that's what they did here. They called the private to come get her, but that resulted in a few minute delay, which is not a long time. Once she got to the hospital, the fetus had bradycardia and there was an emergency C, and the baby died 3 days later. This was another case where the paramedics' conduct was willful and wanton and sent the case to the jury. And this one settled before trial. So, in cases like this, where something very tragic happens, and it's very unexpected, these two, you're going to want to make sure that you have very strong medical records to support what you did. Because even though the judge ruled that it could have been willful and wanton conduct, it doesn't mean the jury would have found you responsible. But usually in a case like this where the injury is so severe, no one is going to want to send a tragic case like that to a jury because it looks like a high verdict. Questions? Have I been too brisk?
In the beginning, we were talking about the difference between working for a municipality and a company that works for a municipality. So that would cover like companies like ProMedica and Mercy.
Yes.
Those things. There's no difference.
Right.
Okay.
I can go back to that. That statute is really long and boring. I had to read it like 3 times. Because I thought, well, is there a difference if you're working directly for the county versus working for someone else? But there isn't. If you're operating under contract or in joint agreement with one of the political subdivisions, so for that, that means like the county or the city or some sort of municipality.
Ronnie, we got like private ambulances who are contracted to cover 3 townships, so to speak. That's what we're talking about here. But a private ambulance company with a contract with a nursing home
Right.
to do a transport out of there, that is not part of this.
You got it.
Okay.
What if that private ambulance company is on the county board to do county runs?
Are you on a county run when it happens?
Oh, so it has to be, you have to be on a run for the county.
Yes.
when it
Yeah,
happens. Okay.
you need to be like working in that capacity to get the higher standard.
So how would that work then? Let's say I'm a paramedic on transport and I'm contracted with Portage Valley and Pemberville.
Okay.
We go out there, just they call us, hey, come on, pick up Miss Sally because of whatever. I go up there and screw up.
Yeah.
How is that covered differently than if I worked for Lucas County EMS and screw up on a call there?
Sure. If you are not working for a county and you're working privately, then we go back to this medical negligence. So negligence is a lower standard than willful and wanton. Negligence means that you didn't do what a reasonable paramedic would do, which is different than saying you willfully and wantonly injured somebody. So this covers, like, you can make a mistake and it's negligence. Sometimes it's not, but sometimes it is. But if you're not going to make a mistake and be held for willful and wanton.
Why is that different? I mean, it's the same.
You're doing the same action, so why should it matter?
Right.
The difference is that there's government immunity. So, suing your government is difficult to do. They've got to do something outside the general standard, not just paramedics, but let's talk about police officers, politicians. Generally, if you're working on behalf of the government, you have immunity absent some very narrow exceptions. But if you're a doctor in a hospital here, let's say it's not UTMC and it's ProMedica, then you're just held to the general medical malpractice standard.
Because it's not a state institution.
Right.
Can they come at you civilly individually though?
you should have a policy of insurance. So you'll be named individually in the case, but you're probably covered under some insurance policy by the company that you're working for. And so you shouldn't be held individually responsible unless, let's say the limits of the policy are $1 million and the jury verdict comes back at $1.2 million, then someone could try to collect $200,000. They don't often do that, but that's an issue that's out there, and that's why I always tell people to make sure you have enough insurance. But I deal with insurance claims all the time, so I'm kind of predisposed to think that.
What's the best way to find out from your employer if they have that?
I would think you could just ask them, like, you know, what sort of liability insurance do you have for us, and they'll tell you. I know like doctors and nurses carry their own policies, or sometimes the hospital carries policies for them, or both. Similar to lawyers, like I have malpractice is something that someone could claim against me, and so the firm is paid for me to have malpractice insurance, and I asked them and they told me, you know, how much the coverage is worth.
I was referring more to like a community aspect.
Oh, if you're working for the government?
Yeah, how do you find out if they are affiliated enough for you to be covered by that community?
I would say you could certainly ask the company that has contracted with the government, but I think you're safe to assume that if there is some sort of agreement between the company you're working for and some sort of government, you're covered under that statute.
But you have to be acting in that capacity,
Right.
correct? So it basically has to be a 911 call.
Right,
It can't be like an inter-facility transfer from hospital to hospital.
right,
It has to be a 911 call.
right.
Now, how does that work if you're contracted like for a hospital-based system and you get a scene request? Like if you go to a scene for, like I work on a mobile ICU, so if
Okay.
we're requested to a scene,
Mm-hmm. And you're working for just the hospital, and
but
it's not
we're
a
working for
government
just
agency.
the hospital, while we have a contract with the government agency or
Right.
we're requested by that government agency, do I fall under that or do I fall under
If you're
what
requested to the scene by a government agency, then you would fall under the government
the government
agency.
agency, not what the not if I'm going to hospital.
Right. If you're going hospital to hospital, you're still gonna be covered by the hospital, but it's just a different legal standard of what will apply.
Let me ask you this. My fire department does transfers from hospital to hospital. While it's not a 911 call,
Mm-hmm.
we're still a fire department.
The fire department is a government agency.
So even though I'm going hospital to hospital, it's not, I'm still a government agency even though it's not a 911.
Yep.
Okay.
Does that make sense?
Yeah, so
that's
if
a good
you're
question.
Government vehicle.
a government agency, then no matter what, you're covered by the,
Willful and wanton standard, the
but
higher
otherwise
standard.
you're only covered from a 911 call with a company that affiliates with
Right.
a government agency.
Yeah, if you're doing, like you said, like a nursing home transfer, there's no government agency involved, it's just private entities doing their thing, you're gonna have the medical malpractice standard, which is a little bit lower. But you'll still I mean, you're still gonna have coverage and insurance, so I wouldn't, you know, while that's not great, I wouldn't be too concerned about it as long as you're covered, and I'm sure you are. Because otherwise the hospital is gonna have to pay individually, and they don't like to do that.
Yeah.
They get insurance. Any other questions? You guys are all gonna write like the best run reports ever?
Definitely.
The people who started writing 2 and 3 sentence reports understand why I said you can't do that, right?
Yeah.
Okay.
Yeah, I've done that.
Stacy.
Yeah, I can show you where are they at. These ones, don't
Yeah.
do these ones.
Yeah.
So we came, we saw, we conquered, is not.
They even spelled left.
Got it.
They said let.
We were always told,
Whoops.
growing up, you know, so when we first started, you had 24 hours to get your report done. Is that still accurate?
I mean, I think doing it within 24 hours is fine. You wanna try to do it as contemporaneously as possible. But doing it within 48 hours is better than not doing it at all, you
Right.
know, so
Yeah, you
try
all-
to get it done in a timely fashion.
I just didn't know what the law would say. I know there's company policies that dictate things, but I thought legally you had, like if something happened and you didn't get it done for 20 hours, you weren't under the gun
Right,
from the law at least. It might be
Yes.
from your company, but,
right.
okay.
Yeah, the companies have different policies, but doing it within 24 hours should be fine, I believe. But I can't help you if you get written up or fired.
Right.
So don't do that.
Yeah.
With having, internet-based, reporting systems, does it matter if you do that, like, on your personal computer, you write your report on your personal computer, even though it's going to the, like, we use ESO,
Mm-hmm,
so ESO is web-based,
mm-hmm.
nothing gets saved on your computer at all, it's all saved on
That's what I was gonna ask you.
it's all saved on the actual ESO itself.
Yeah,
So, as long as documentation isn't saved or anything like that, you're fine.
right, I agree. The only, if you were to get in a case and the other attorney asked you, do you remember where you wrote this report? You can say, well, it's my practice that I write down on my personal computer. I'm sure he's gonna ask you, but do you have any drafts saved? Do you do more than one version? And then you would just need to explain, I put it all in this web-based system, nothing is saved to my personal computer. And then they really shouldn't have a strong case for trying to get any of your personal information or documents from your personal computer.
Again, company policy would probably come into play here.
Yeah, that's
That's
always
that
something
part.
that you could point to and say, I was following what, the rules were, and that will always reflect well on you.
Anything else, Gary?
Yeah, they're videoing this, so you have to ask questions for
Yeah.
every other
All the other
student ever.
That's right. Well, thank you very much.
Yeah, thanks for having me.
Very, very insightful and